Andrea Kane, and I'm here with you for HIT 445 Quality Management, and we are on the last lecture video for week 6 on chapter 20, and this is a nice short one. So let's get to it. We're understanding the legal implications of performance improvement. So the learning objectives according to the book are to look at the legal aspects to PI activities and explain the significance and relationship of tort law to quality improvement, look at the concepts of protection and privilege, and then distinguish quality improvement activities from research because they are different. If you think back to HIT 421 that you had last spring, hopefully you learned about tort law. That's a wrongful act committed against a person or a piece of property. It's a civil action, not criminal. And it's typically involved with healthcare negligence, which means it's unintentional. Tort law does include intentional wrongful acts as well as unintentional, but negligence, you need to have in mind, means unintentional. And then so you want to make sure you're avoiding risk from a medical malpractice perspective when it comes to unsatisfied patients, loss of market share, and exposure to legal action in the form of malpractice litigation. The basic elements of negligence or malpractice were that you had a duty, you breached the duty, you caused damages or injury, and those damages or injury were a direct cause or directly caused by your breach of duty. You have to have those 4 things in order for litigation to move forward when it comes to tort law. Okay, you have to have a duty, you have to have breached that duty, you have to have caused damages or injury, and the damages or injury were directly or indirectly caused or a foreseeable cause by that breach of duty. Peer review is protected, and in most cases it is, and you want to keep it that way. So everything has to be super confidential and maintained, and it has to have that on every document that it is peer review, it is confidential, it is attorney-client privileged, that kind of information. The Federal Healthcare Quality Improvement Act of 1986 made the peer review process more effective because it made it immune from liability. And so that was really important. You can take a look at your textbook for more information on that. Occurrence reports, those should be protected from being used as evidence in medical malpractice case as well as your information on sentinel events, but you have to make sure you have protected it, that you've labeled it properly, that you have not disclosed it inappropriately outside of your policies, procedures, rules, regulations, that type of thing. It only applies to the discussions and materials from peer review meetings, so you have to be very careful about what you call peer review and how it's labeled. And the facts of what happened must be disclosed, although you don't have to show the forms. There is responsibility for disclosing adverse events to the patient and family. You need to make sure that there's a factual explanation of the circumstances surrounding the adverse event. Explain the impact of the adverse event on the patient's treatment, including treatment that may not have otherwise been necessary. What steps have been taken or will be taken to correct or mitigate any injury, and assurance that the physician and other members of the patient care team will remain available to discuss any concerns that the patient or family may have. So these are all aspects from a legal perspective when it comes to performance improvement and some of the outcomes. I know your chapter actually has more information than that. This slideshow this time around was a little bit brief. So just encourage you to read the chapter, make sure you look at the key terms and understand those, and do your reviews. All right, that's it for week 6. Take care, and we will come back week 7, and we will talk about budgeting. Have a fabulous week, and if you need me, reach out through email, okay?